Mr. President, it seems hard to imagine that it was 23 years ago when 3,000 Americans were killed in a terrorist attack in New York City and here in Washington, D.C. at the Pentagon. The families of those who lost loved ones that day have been seeking access to justice, just like any other victim could and should be able to here in the United States. To that end, we introduced the Justice Against Sponsors of Terrorism Act, or JASTA, which was a monumental step to allowing those families who lost loved ones to achieve long overdue closure in a court of law. It did not put our thumb on the scale. It didn't say they were entitled to anything. It said they were entitled to present their arguments and the facts to a court of law, just like any other American citizen should be able to do so here in our country. These terrorist attacks on 9/11 were a tragedy for our entire nation, but for some, that day was a personal tragedy as well. Men and women who lost loved ones during the terrorist attacks deserve to have their day in court. Thanks to JASTA, as it's called, the Justice Against Sponsors of Terrorism Act, that is now possible. This legislation, the Ensuring Justice to Victims of Terrorism Act, provides important updates and technical edits to the original bill. To show you the sort of bipartisan support that this carve-out in foreign sovereign immunity law received, it passed 97-1 back when it originally passed, and it passed over a presidential veto by President Obama. The bill before us today does not expand JASTA's original scope as intended by Congress, but it does correct certain judicial misinterpretations that fly in the face of the clear text and the history of this legislation. When President Obama vetoed JASTA, leading to the only veto override during his presidency, he listed a parade of harmful potential foreign policy outcomes to justify his refusal to stand up for American victims of terrorism. None of these predicted negative outcomes have come to pass, and JASTA has been the law of the land for nearly a decade. These technical corrections will not change that fact. It will ensure that the families of the victims of these tragic attacks on 9/11 receive the justice they deserve, and I hope it will advance out of the Senate today. To that end, Mr. President, I would ask unanimous consent that the Committee on the Judiciary be discharged from further consideration of S. 2082, and notwithstanding Rule 20, that the Senate proceed to its immediate consideration. Further, that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid on the table.
Is there an objection? Senator from Arkansas.
Reserving the right to object, I first would like to begin by joining my colleague from Texas in mourning the loss of the nearly 3,000 innocent Americans who died in the September 11th attacks. We must never, and we will never, forget them. I also want to extend my prayers to the families who lost loved ones that day and who bear the weight of their loss in their hearts every single day. However, I must object to this bill today because it hasn't yet received the careful consideration and deliberation that the subject warrants. First, and contrary to some suggestions, the bill would enact more than mere technical corrections to earlier legislation. Rather, the bill's provisions would significantly change how a highly technical area of U.S. law is interpreted. But the Judiciary Committee hasn't held a hearing or a vote on this bill. Not the fault of the senator from Texas, to be sure, but a fact nonetheless. I also question whether the Foreign Relations Committee should evaluate the bill as well, given its consequences for our foreign policy. Second, and speaking of foreign policy, the bill could have far-reaching and consequential implications for our policy in the Middle East. Thanks to Israel's artful diplomacy and incredible military, Iran's so-called axis of resistance lies in rubble in Gaza, Lebanon, and Syria, with Iran itself therefore exposed on its flanks for the first time in a generation. I would suggest at this highly promising yet highly sensitive moment that all our efforts should be focused on uniting our friends and our allies in the region to put an end, once and for all, to the threat of a nuclear-armed terrorist sponsoring Iran. Finally, this bill could have the unintended but unwelcome result of further delaying resolution and recovery for the 9/11 litigants' cases. The courts will likely need to reopen and relitigate past decisions based on the changed law, while a disproportionate amount of any future recovery could go primarily to insurance companies and lawyers instead of the families of the victims, if any recovery comes at all. For these reasons, I must object today, while suggesting that the new Congress revisit the matter with the hearings, regular order, and full consideration that the subject deserves. I yield the floor.
Objection is heard.